As you're aware, we expected Male Mabirizi to be produced in court today. The initial date he was supposed to appear in court was Friday, the 20th, which happened to be Eid. And legally, when an action is supposed to be done, or if court is supposed to do anything and it was on a public holiday, the next day is the date that is considered. We were surprised, of course, when he appeared in court and prison does not come with Male Mabirizi. They only brought his remand warrant without him. And the presumption, and you heard me addressing the judicial officer, she says she has to first issue another date. But we do actually object to that, because we're saying from the 17th of March, when the Constitutional Court nullified the law under which Male Mabirizi is being tried, and specifically those sections 26, 28, and the whole act, and issued a permanent injunction restricting any government institution and anyone from enforcing the provisions of that act, then it means anyone who was undergoing trial, Male Mabirizi and others, should have been stopped forthwith. The order was very clear. Now, there's no judicial officer can insist. The Chief Magistrate is insisting on a decree that you need to obstruct a decree. You cannot insist on a decree when you have a certified copy of the judgment, the judgment of the Court of Appeal. It is uploaded on ULI. ULI is the property of the judiciary. It is managed by judicial officers. If she has any doubts as to that order, she can consult fellow judicial officers. Recently, we saw a directive from the Chief Justice himself saying the courts are going paperless, meaning everything, what is uploaded, everything, whether it's a decision, whether it's any order of court, it is uploaded on ICMIS, it is uploaded on ULI, and it should be respected. Now, when you look at the law, the certified copy of the judgment which you provided her alone is enough to actually show that this is what court decided. She should take judicial notice of that. Now, these technicalities of saying I need a decree, Male Mabirizi is not a party to the constitutional petition. Now, the Uganda Law Society and other parties, and if the other parties are not even interested in maybe executing, it should not prejudice or affect a third party, especially in a case like this, which should be self-executing. The orders are self-executing from the date that order was issued by court. That decision was made and uploaded on ULI, signed by the justices of the Court of Appeal. Every institution of government should respect that. In essence, she's saying if there is no decree, that means Male Mabirizi and others will stay in prison. What if the other parties don't push for a decree to execute it? What if they're not interested in executing? So the argument is, and we're telling her, even if it's requesting Male to appear in court, you have no business doing anything in respect of this case. Whatever you do, whatever action you take, other than having him released, other than him being discharged from prison, is an illegality. You will be breaking the law, and it will actually amount to misconduct, judicial misconduct, because you cannot do things. Once an illegality has been brought to the attention of the court, you cannot ignore it for a judicial officer. So these technicalities of I want a decree from court for me to release them is wrong, and we are waiting to see the actions they intend to take. If we brought him to court, what are you going to do? Because if the Supreme Court, the Constitutional Court, the higher court, the court superior to this has said do not do this, and you continue doing it as a judicial officer, you're breaking the law.